Good morning. Can you hear me? Yeah, okay. I have the pleasure today to welcome Professor Francesco Palermo, who is Professor of Comparative Constitutional Law at the University of Verona. He is also Director of the Institute on Comparative Federalism in Bolzano. And something that is quite pertinent to our lecture today, he wears also a second or a third hat, the hat of being a member of the Italian Senate at the moment, which means that he's going to talk about bicameralism, or not only from an observer perspective, the perspective of the scholar interested in analyzing in a quite detached way varieties of bicameral systems, also from the perspective of a participant in the activity, in the functioning of one of those upper chambers. He is a very prolific scholar, and 4 years ago he published with another colleague from Verona, Matteo Nicolini, a volume on bicameralism. It is a book in Italian. The title is Il bicameralismo, pluralismo e limiti della rappresentanza in prospettiva comparata. And if you are interested in exploring more in depth the topic of today's class, this is certainly a source that you can benefit from, because it offers a very rich empirical basis and important also theoretical considerations. Before leaving the floor to Francesco Palermo, I would like to situate the topic, in particular with a view to what we have done so far in the course. We are studying the norms establishing and regulating government, and in particular, at the moment, the forms of government. In the analysis of the parliamentary form of government, we have stressed, of course, the key role of parliaments. Although I specified that in the discussion on the parliamentary form of government or monist forms of government, when we talk about parliament, we mainly refer to one part of parliament, to the lower chamber, the chamber that represents in general the polity, the nation, the citizens. But if we look at many constitutional systems in Europe and in the world, we notice that the parliament most of the times is organized with a more complex structure. It seems like that the general representation of citizens is not sufficient to account for the social reality, the political reality of a country. And therefore, a complementary element is required to integrate representation in the parliament. This is the role traditionally played by second or upper chambers. And when we talk about bicameralism and varieties of bicameralism, our focus, our emphasis is mainly on the second, although not necessarily only on the second chamber, and therefore on the upper chamber. I've asked Professor Palermo to try to offer a presentation on the topic, which is a very rich topic, and therefore it will be difficult that the lecture will be exhaustive, but at the same time we would like to center our focal point basically on 3 issues: on the rationale, on the reasons justifying the establishment of a second chamber, of a bicameral system; secondly, on the composition, on the structure of second chambers; and thirdly, on the functioning, on how they operate within legislative procedures or in the relationship with the cabinet, the executive. Having said this, I leave the floor to Francesco Palermo, But before, I would like really to thank him for having found the time to come to Trento and to teach us this lecture.
Good morning, everyone. Thank you very much, Marco, for these nice words. I'm not sure that the microphone is working. I'm gonna, either it's a very, very good microphone that I don't hear the, or it is. Yeah. All right. Then I will have to sit most probably.
Yeah. I'll
yeah. Shall I shout? No. Yes. Okay. Well, again, thank you. And as you said, the topic is actually extremely rich, and I'm not so sure about your level of preparation so far. And although knowing Professor Dani, I'm sure that you have been dealing with a number of subjects, which is much bigger than what I could expect. In any case, please do interrupt me anytime if you have questions or if something is not clear. Or otherwise we can have a discussion afterwards as you prefer, but I guess it is better and easier if you stop me as we go along in order to clarify some issues and aspects. So you see on the screen the topics I would like to touch upon, and I will start actually with a general structural question. As Marco Dani said, why on earth do we need in most countries to have two chambers? And why is one not sufficient? Actually, assuming that you know a lot already about the rationale of parliaments, the history of parliaments, how they have been established, in terms of creating some forms of democratic, more or less democratic representation, the question arises as to why actually a second chamber is required. For the simple reason that there is a logical contradiction which lies at the very bottom line of the question. So if we need to have a second chamber performing more or less the same functions as the first one, why do we need it, right? If we have one, that should be more than enough. Conversely, if this should be different, doing something different as the first chamber, why making it part of Parliament? Why Parliament? I mean, Parliament is obviously a body representing the citizens in general, the democratic process in a country. So if you have to represent something else, and we will see what this something else is, then do we need a chamber of parliament? Do we need to make something that is not really in line with the very idea of a parliament? Don't we preferably have something different, a different institution performing the scope that it was created for? All right, so I think this is a contradiction that remains even in present days, and we will see it based on a few examples. Well, while also in ancient times there were traces of embryos of bicameral systems. For example, in Rome, there was the Senate, but also the comitia in Latin, which were doing, to some extent, things that can be linked to the different form of representation in two chambers. We cannot obviously speak about bicameralism outside of the context of parliamentarism. So we need to have modern parliaments to speak about bicameralism, quite obviously. It is only in modern times, with the establishment of constitutionalism, that we see the birth of both parliaments and second chambers in these type of parliaments. Well, it is quite paradoxical, and this is a whole story of paradoxes, as we will see during the lecture this morning. It is one of the first paradoxes is the fact that actually the prototype of the second chamber has been and still is the British House of Lords, which is actually the manifestation of a pre-modern parliament, which is a sort of a feudal heritage of a system which is pre-modern. But it has remained as you know, the oldest second chamber that exists and has been established even before the parliaments themselves have been established. Now, apart from that, the second chambers really spread out with the spreading of constitutionalism as such, and therefore, especially in the 19th century, we have to notice a number of, you know, a big proliferation of second chambers, more or less in all the systems, for sure in Europe, but also outside of Europe. And they have been originally established as limits, as breaks, as chambers of second thought, in order to slow down the democratic efforts that were represented in proper parliaments, in lower chambers. So actually, the first purpose of second chambers was that of, you know, limiting the effect of what we call now democracy and democratic representation in the first chambers. The members were normally not elected, quite obviously, in such a concept. They were either appointed by the king, like in the Italian Senate under the Albertine Statute 1848, or just indirectly elected by either some notables in some countries, or by people already elected to some regional, provincial assembly. This is why this aristocratic origin has even shaped the name. We are still calling the the senates, the second chambers, as upper chambers, considering that, you know, the lower chambers are the democratic things where, you know, the people with just a negative connotation is represented, and the upper chambers means where the aristocracy is represented. So, in fact, in the Netherlands, which is also a very ancient constitution, the two chambers of parliament are called first and second chamber, just Eerste and Tweede Kamer. But the interesting thing is that the first chamber is actually the Senate, the upper chamber. It's the first, and the second is just the popular one. So just to show examples of how actually this aristocratic heritage does continue, even in terminology today. By the passing of time, not only the upper chambers function is represented in the various varieties that we can comparatively observe of second chambers, but also many other functions that we will then explore more in detail. Another very important typology of second chambers is what we can call the federal second chamber, so the chambers of states, of subnational units coming together in a federation, and we will speak more in detail about that. There is also a deviation from this model, which we call an ambassadorial model, which are territorial chambers that are not really, you know, the chambers representing the states in one model, but in a different way. If you don't understand, don't worry, I will clarify it in a moment. Then we have still second chambers that were established especially in different periods of constitutional history when certain other aspects were considered to be particularly important. And one example is the chambers, the second chambers representing corporative interests. You know, professions, specific expertise, trade unions, and so on and so forth. This model was quite popular, especially in the 30s and in the 40s. Some countries went for a proper second chamber in that respect. The Irish Senate, for example, is still composed like this. Some others went for a sort of a third chamber, which is not precisely part of the parliament, but is kind of linked to the parliament. We have in Italy, as you know, especially after last year's referendum, when this was at the core of the reform, at least in terms of what was portrayed as the objective of the reform, the so-called CNEL, National Council on Economy and Labor, which again, back then was considered to be an important addition to the parliamentary representation. The same happened in France with a similar council. The same still exists in the European Union, which has very limited functions, but still is still there. Now this model is clearly not en vogue, is not very popular anymore, but still there are some chambers that represent this sort of corporative element. Then we have mixed chambers, chambers that try to represent different sources of legitimacy, different territorial, political, democratic, aristocratic elements all together, and we will see some examples. And not least, especially in ethnically divided societies, we have second chambers that, rather than representing the general political representation or corporation or subnational units, they tend to represent ethnicities as such, as constituent element of the state. So as opposed to the democratic representation that is present everywhere, the ethnicities, the ethnic groups as such, the nationalities are represented. And we also have so many different types of second chambers that we could actually wonder whether we can speak of second chambers as a whole. Does it make any sense, or should we look at the different functions that these second chambers do perform? Well, I guess yes, at least in respect of one main function, because despite of all these diversities that we will look at more closely in a moment, there is one common element that is transversal and affects all different types of second chambers. The idea of representing pluralism, which is, as you know, the other side of the coin of constitutionalism. Constitutionalism has been established because societies were becoming more plural, and therefore there was a need to represent and integrate all the different voices in society and giving them representation at the central decision-making level. So, regardless of the different types of plurality that these second chambers are called upon to represent, they all represent the form of pluralism that was considered important at the moment of the formation of the respective constitution. Some countries chose the federal option, so the representation of subnational territories. Some others chose a political form of representation, a corporative, an ethnic, a mixed one, and so on and so forth. So I think the red tape that links all the different forms of bicameralism is the attempt to represent pluralism. And then, of course, each country makes its own decisions as to what form of pluralism, next to the democratic political representation in the lower chamber, they wanted to go for. Right? Any questions so far? I mean, this is what keeps them what all the systems have in common. Now, let's start, and I will focus most of my presentation to that because it is certainly the most colorful, the most numerous, and also the most interesting, perhaps, form of bicameralism. I would like to start with the second chambers aimed at representing territorial pluralism. So the fact that a state is not only composed by the population and the classical categories in public international law, population, sovereignty, and territory, but also that the territory is not unitary but composed of also a number of other territories that are constitutionally recognized and guaranteed by the very constitution. So we have actually many cases of second chambers that aim at representing territorial pluralism. But within this general purpose, we should identify for classificatory purposes at least two main different types of federal second chambers. Two profoundly different ways, according to the structure, according to which this representation is carried out. One is the so-called Senate model, which is by far the most numerous. The other one is the ambassador model or council model that we will touch upon in a moment. I have tried to summarize the main structural elements that characterize this system of the so-called model of Senate, which was, as I know Professor Dani also mentioned already to you, modeled according to the prototype of the US Senate, which is a typical senatorial second chamber aimed at representing constituent units of a federation, right? What are the structural elements that characterize this model? First, the fact that the members of these chambers are elected either directly by people or indirectly by subnational legislatures, means the parliaments of the subnational units. I'll come back to that in a moment, because as you probably know, even in the United States there has been a shift between one model and the other. As a rule, these chambers tend to represent the subnational units on a parity level, independently of the size, the population, the economic power, the territory. As again in the model of the US Senate, you have Delaware, which is very small, and you have California, which is nearly as big as Italy, having both the same number of senators. Why that? Because the democratic element, the size of the population, doesn't count. This was due to the famous Connecticut Compromise, which was the compromise reached at the time of the Constitutional Convention in Philadelphia, 1787, when the US Constitution was drafted, and it was not by chance named after the state that brokered the agreement between the biggest and the smallest states. Of course, each category having its own political interest. The big states wanted to say, no, no, we are big. We need to be, you know, bigger also in the Senate to have a bigger weight. And the smaller states said, well, wait a minute, why should we, you know, agree to a compromise that makes us a structural minority in the Senate? We will never, you know, be able then to make our voice heard if we do not have the same voice. So the compromise brokered by Connecticut was precisely to establish two chambers, saying, okay, on the one hand, we need to represent the population according to the size of the population. And that we do in, you know, the House of Representatives, which is elected according to the population. But on the other hand, we split this representation and we establish a second chamber of the national parliament, which is called the Congress in the US, where we do not care about the population, we care about the states. There are two different foundational elements of our new system, the people and the states, and therefore each one has its own representation. People is represented accordingly, so according of course to the size. The states are represented based on the fact that they exist, not on their power and on their size. So that's the normal case. Still, most of the senatorial second chambers that have, you know, directly or indirectly evolved out of the US model have this equal representation of the subnational entities. The third, and in my view, determinant element of this model is the free parliamentary mandate. The US senators are members of parliament. They are much more powerful, of course, than the representatives for a number of reasons, not least the fact that they are elected, as you probably know, for 6 years, whereas the poor representatives are elected for 2 years, so they are basically constantly and only in a permanent electoral campaign. Whereas so the senators are less numerous, politically much more influential, etc. But they are, and this is important, free in terms of representation exactly the same way their colleagues in the House of Representatives are. Nobody can give them instructions. They are not bound by the states that elect them, right? And this has a fundamental consequence, which, as we will see at the end, probably even put into question the whole category of, you know, federal bicameralism. If you are a free parliamentarian, a member of parliament, you are not bound by any instruction, then what would be the criterion, you know, to group together? The state where you're coming from or the political party you belong to? Well, guess what? Of course the political party. It's just a political affiliation. And now you have, you know, the senators that sit together as Republican senators, Democratic senators, right? And the state where they come from has not so much influence on their way of voting, on their political behavior. So, as a matter of fact, in the course of history of the US Senate, but also of all other senatorial second chambers, the trend is pretty clearly recognizable. From territorial chambers, they turned into political chambers. So the territorial logic goes, you know, in the back, and basically only matters when there are elections for the candidates of the Senate. But then, you know, in the practical work, doesn't count anymore. Okay, back to the equal representation. Of course, this can be done in different ways. You can have the very same representation of each state according to the US model. You can even have a similar rationale which is followed in Switzerland, the cantons, although they are much less, different than the US states in terms of population, but still there are some considerable differences. There are cantons in Switzerland with 20,000 inhabitants, and the canton of Zurich has 1.5 million. So still a remarkable difference. All the cantons are represented the same way in the Chamber of States, except for 6 that are the formerly so-called, now no more, half cantons, but the terminology has kind of remained in the political terminology, which means that they are these cantons that are divided, that used to form a unity but are divided for some specific reason. Basel, town and country. Appenzell has 2 different parts, and so on and so forth. That's historical reasons. These countries, these half cantons, as they are called, they only have 1 representative in the Swiss second chamber. But apart from this distinction, which has historical reasons, even in Switzerland, the representation is the same as in the US. 2 members each canton, irrespective of the size. But as I said, there can be also other rationales for creating a homogeneous, identical representation. The classical example here is Canada, where the Senate is composed by the same number of senators, not for each province, but for each region, so bigger than province, created at the moment of the national unit, 1867. What was the idea there? Of course, to create a balance between Anglophones and Francophones in particular. So, there are groups of provinces that have the same weight. The Atlantic provinces, the Pacific provinces, the Central provinces, they all have the same number of senators. And then, not by chance, the 2 big provinces, Ontario and Quebec, have, the same number of senators each, and they are, being so big, at the same time provinces and senatorial regions. So they also have the same number of the total of the Atlantic or of the Pacific provinces. Anyway, without going too much into detail, the rationale is pretty clear. So they wanted to represent not the individual provinces as such, but the individual regions composing Canada equally represented. Now, as to the first criterion, the election, this has remained. But interestingly enough, there has been a clear trend to move from indirect to direct election of these members of second chambers. I need to speed up, perhaps. Again, the US represented the model because, as you probably know, in 1913, the 17th Amendment was adopted, according to which the senators are no longer elected by the parliaments of the states, but are directly elected by the people of that state. The number remains the same, but the election is a popular election. And not by chance, at the beginning of the 20th century, this development marked also quite a number of other similar second chambers. It was the same for Australia, even earlier in 1900. It was the same in Mexico, in Brazil, in Argentina, etc., etc. Why? Well, of course, because the 20th century was the century of the spreading of the democratic idea. So it was considered to be, more legitimized if the senators were elected by the people rather than by the parliaments of the respective state. And so, as a matter of fact, this also helped a lot to establish the move I've been mentioning before, so the prevalence of the political over the territorial logic, right? Even more if they are elected directly by people, members of second chambers are, political representatives rather than territorial representatives. And so the political dimension became even stronger over the territorial dimension. Still, there are other models of the same type of second chambers that provide for an indirect election, meaning they are essentially elected by the legislatures of the constituent units. That's the system we still have in Austria, the system in Belgium, well, okay, with some additional elements, in India, notably, and so on and so forth. Well, for those who are interested in constitutional epistemology, as someone also calls that, exotic examples, there is also a case of a federation, which is a federal country, which does not have a second chamber. It's only the archipelago of St. Kitts and Nevis, basically two small islands creating a federation, and they only have a chamber. Okay. Not, for sure, not, I guess, a question for exams by Professor Dan. All right. So then study St. Kitts and Nevis, but if you have to do it, then basically you should do it there rather than just on the spot. All right. Let's move to the second big model of federal second chambers. This is what we call the ambassador model or council model. Why that? Because the logic is entirely different. I mean, again, they want to represent the territories of subnational entities of a federation in general, but they do it in a completely different way. These are, that explains the name, ambassadors rather than members of parliament. And of course, ambassadors have a completely different status than members of parliament. Why? Because they are bound to instructions, right? An ambassador is not free to decide how to negotiate, what to negotiate. They have to follow the instruction of their government. So again, here, parliaments don't play a big role, and even less the people of the involved subnational unit. It's the government of that unit that determines both the appointment of the members and the political behavior of the members, right? So they are not elected, therefore, of course, each time a subnational government changes, also the representatives in the second chamber of that model change, yeah? And also their political affiliation change. Normally, these chambers are not composed in an equal way as opposed to the majority of the Senate second chambers, but they are composed according to a weighted representation. Means that, you know, the bigger subnational units have more representatives than the smaller, even though in proportional terms the smaller ones are, you know, represented more strongly than the big ones. Classical example being Germany, where you have Saarland with 3 members and Bavaria, which is a lot bigger, with just 6 members. But Bavaria is much more than 2 times the size and the population of Saarland. And again, the mandate is based on instructions by the government. Well, the question is whether or not, actually, this is sufficient to keep the representation of territories rather than the representation of political choices made by the respective government. Well, in principle, yes, of course, because, you know, ambassadors represent their territory. They are not they're not so free to decide. But obviously, the subnational governments have their political connotation. And this is something that, especially in Germany, has been, you know, a constant problem for all the governments that were not formed on a big coalition between the biggest parties, where, of course, then it was no problem to reach a political majority also in the Bundesrat, in the second chamber. There was even a case when the Constitutional Court was called upon to clarify this aspect. A very important case. It was in 2002 when a very contested law on immigration, and you can imagine that even back then, now it would be even worse, it is difficult to adopt a law on immigration. Back then, the political majority was between the Social Democrats and the Greens, so a left-wing majority at federal level. But when the law came to the Bundesrat for its approval, well, the government of one key land had changed from a similar majority to the political majority at federal level, so from a left-wing majority, to a grand coalition between Social Democrats and Christian Democrats. What is generally the rule if a government is a coalition government and cannot reach a common position in the voting? Well, normally the vote is abstention. So this land does not vote, right? Because all the votes should be cast together en bloc. Well, in that particular case, as the topic was politically so sensitive, and the two parties, Social Democrats and Christian Democrats, were, supporting opposite views on the issue of immigration, there was no agreement on that. But, still, for the first time, the representatives of the Christian Democrats from Brandenburg in that particular voting in the Bundesrat decided to cast their vote too. So they said, okay, our colleagues, Brandenburg had four votes. The two votes from the Social Democrats were cast, and they claimed this is the position of the land. The Christian Democrats representatives said, no, this is not the position of the land, and actually, we want to express our position, so it's 2 and 2. And this was, then considered by the political majority back then to not be valid, and that the valid vote was only that expressed by the Social Democrats, and therefore the majority was counted in favor of the law, and the law was adopted. Then, of course, the Christian Democrats went to the Constitutional Court and claimed that the vote there in the Bundesrat was invalid, and the Constitutional Court told they were right. So actually, these in the case of no agreement within a government, then obviously the land does not have a position. Again, what is important is that the votes are cast together, irrespective of the different political views. So the law was declared unconstitutional because it had failed to be adopted according to the right procedure. So quite a heavy case, right? But just to explain how sometimes the territorial logic prevails, but sometimes what motivates the territorial logic is extremely political, right? So also these type of second chambers are not alien from political considerations. Rather the contrary, they are intimately political chambers. Well, if you are bound by instructions, you cannot decide how to vote. And even if you cannot split the vote among the representatives of one particular subnational unit, if you are, in other words, as I was saying before, an ambassador rather than a member of parliament, is this a chamber of parliament? I mean, you know that the very essence of parliamentarism is that members of parliament are free. They even have criminal protection. They have immunity for their position. I cannot be put in jail because I express a position. I can say whatever I want right now because I'm a member of parliament and I enjoy immunity. So this is a strong protection of freedom of individual members. This doesn't apply to here. So are they really members of parliament? No, they are not. This is the paradox that the really territorial second chambers, the ones really representing the territories, Well, they might be called second chambers if you so wish, and especially because you have a number of functions that are parliamentary in nature, but you are not a chamber of parliament. The German Bundesrat is not the second chamber of the federal parliament. Germany as a unicameral parliament, plus there is the Bundesrat that makes, as a matter of fact, a number of tasks that are parliamentary in nature. Well, this is a very efficient system, right, in terms of representing territories. If you want to represent a territory rather than political orientation, then you clearly go for this model rather than for another one, right? Because the other one is so much political, then in the end it kind of duplicates, perhaps with different political majorities, the same representation in the lower chamber. So one would think, well, territorial representation should be pursued in first place by these means. Well, what happens is that the system is essentially just a German phenomenon. It hasn't spread out. Well, the Council of Ministers of the European Union functions exactly the same way. Well, for various reasons, for the aggregative nature of the European Union, some others might think just because of the German influence over the European Union, and therefore they just want to impose also their own constitutional system to the extent it is possible. Anyway, this is the only existing model that basically functions the very same way. Why is such an efficient system not so common in comparative practice? Well, guess why? Maybe, so before we have a short break, you should try to give yourself an answer before I give you the answer. Well, to some extent I told you already. Speaking of the aggregative reason of federalism. Now, the federal states, the vast majority of federal states are no longer composed by, previously coming together, previously sovereign entities coming together and forming a federation. They are created by dissolution, by unitary countries that devolve many powers to the periphery. And in such a system, this type of representation doesn't fit at all. That's why, even in the constitutional debate in Italy, or everyone loves to speak about the German Bundesrat because this is, of course, very, very cute. But guess why it never works? Well, because the federalization, or call it as you wish, in Italy is following a completely different path. So we do not have sovereign regions coming together. So this sort of representation would be a little bit at odds with the whole structure of the federal or quasi-federal system. So that's one reason. The other reason is that, well, is this a democratic representation? Not at all. Has nothing to do with democracy, even though there is an indirect democratic legitimacy because the people of the respective land elects their parliament, and the parliament appoints the government, and then the government appoints the members of Bundesrat. So it's, very, very indirect form of democratic legitimacy, but it has nothing to do with democracy. And we said before, as you remember, that actually the overall trend is the spreading of the democratic element. The democracy prevails over federalism in nearly all the Western systems and all the others that have copied that model. Therefore, when other countries decided to follow a model of territorial representation, well, they went for a system which was closer to a true democratic representation rather than a merely territorial one. And therefore, the Senate model is very, very popular, comparatively speaking, and the ambassador model has not circulated. All right, perhaps we can have a short break, and then we look at the functions and at the various functions of federal second chambers, and then we speak not so extensively about the other second chambers. But I'm here also during the break, so if you have questions now, during the break, afterwards, I'm here. Okay, if you don't mind, we resume and continue after having clarified, I hope, the main distinction that is structurally very important, so it is important that it is clear to you. Well, then, of course, as always happens in law, when categories are established in order to help people understand, but of course then the reality is much more complicated than just the categories. That's the typical example of what lawyers do. They have category 1, category 2, and whatever doesn't fit into category 1 and 2 is category 3, which is a sort of a mixed system. So this is also what happens with regard to this federal bicameralism. There are also many examples of so-called mixed or hybrid forms of territorial representation, which means, as I was saying in the outset, to represent more than just one form of pluralism. So not only the territorial one, senatorial or ambassadorial as you want, but still also something else and additional to the territorial representation. That's, for example, the case of Canada, where the Senate is established also following the very important model of the British House of Lords, also because of the British influence over... Devi alzare? Era meglio con l'altro? Era meglio con l'altro, sì. Ok, torno con l'altro. Se fosse possibile. No, aspetta. Grazie. Ok. Well, perché quello è molto alto. Yes. Molto basso. Ok. Wonderful. Pronto? Ok. Grazie. Excellent. No. Well, it happens. So I hope you still hear me well. And in terms of standing or sitting, it's not a big difference in my case. So okay, fine. So the Canadian Senate is an example of both. So on one hand, it wants to represent the territories, but on the other hand, it is a very important. It has a very important moderating function, as the aristocratic British House of Lords has. Other forms of hybrid systems are, for example, to be found in Belgium and in Spain, where you have different categories of senators appointed also differently. In Belgium, until the reform of 2014, actually there were 4 different categories of senators, and now just 2, but it means that there is a very weighted system based on the linguistic groups. So the Flemish that are majoritarian in the country appoint also more senators. Plus there are the French-speaking community, and then even the German-speaking appoints 1 senator. And all the senators appointed according or elected by the subnational parliaments are then electing, sitting together according to language groups, so all the Flemish, all the French-speaking, to appoint additional co-opted senators. It's also a very weird system which has a lot to do with history, but again here the idea is to represent not only the subnational units but more importantly the various language groups making up the Belgian Federation. In Spain the rationale is different, but again here you have 2 senators elected by the population in each province, so it's not the autonomous communities that count. The provinces do elect 2 senators each, equal system, plus there are additional senators that are elected by the parliaments of the comunidades autónomas, the autonomous communities, based on the size of the respective autonomous community. So the bigger every million inhabitants, then one more senator that can be appointed. And this also creates two different categories of senators that then, you know, when it comes to voting, have exactly the same powers in the Senate, but when it comes to the origin and the legitimacy, makes it rather different. Then we have, you know, countless examples, because then each country follows its own internal logic. In Russia, for example, again, 89 subnational units. Each of them appoints 2 members. One is elected by parliament, and one is elected by or appointed by the government of the respective subnational unit. Well, one may argue why that, if the parliament need to, you know, the government needs to enjoy the confidence of the parliament at subnational level. Well, because in fact it's not exactly like that now in Russia, because the governments are de facto appointed by Moscow. So it means that the central power has de facto the possibility to appoint half of the senators in order to, you know, make sure that this chamber functions according to the political orientation of the center. And, you know, even again some exotic case to keep the attention high, Malaysia, also very interesting system, because but the similar rationale, the parliaments of the various subnational units, the various states, appoint the same number of senators, plus the head of the state, the president of Malaysia, appoints 40 out of his pocket. Well, yeah, it's probably a little provocative, but I see what you mean, and in fact, well, something. The Malaysian model was inspiring Mr. Renzi.
The Salgari.
Yes, exactly. Labuan has actually 2 members, and. But one is not Lady Marianne. That was the Pearl of Labuan. Anyway, okay, back to serious things. In these systems, often, besides, you know, some political considerations, and the case of Russia and Malaysia, it's pretty obvious, there are ethnic and cultural elements that play a very, very important role in the composition of these chambers. They are not exclusively ethnic chambers, but, you know, the ethnic element is important as one of the factors of pluralism that this type of second chambers are aimed to represent. There are also very rare cases where you have a mix between senatorial and ambassadorial model. So again, it's not about the composition now here, but it's about the way of functioning. And the most notable case is that of South Africa, where we have the National Council of Provinces, which is again elected according to a paritarian system. So each province, irrespective of the population, has 10 members, appointed again by the governments and by the parliament. In that case, it's not so much in order to grant control by the central government, but rather to make it possible for political minorities within the parliaments, the subnational parliaments, to also appoint some senators. The governments, of course, have a political color, and therefore the parliaments also account for appointing out of the 5 that are appointed by parliament also members of the political opposition. And it works as a senate or as an ambassadorial chamber depending on the subject. When interests of the provinces are at stake, for example, constitutional amendments, for example, matters that follow into the exclusive competence of the provinces, or rather into concurrent legislation, then it works like the German Bundesrat. Then it is block vote by each province. So they cease to be free members of parliament, and they, you know, put the hat on of representatives of their respective province. When issues of general interest are affected, which have nothing to do with interest of the provinces, then of course they still vote as free members of a parliament. So again, this is, you know, two functions within the same chamber, which is also very interesting, and also a very unique case that has not circulated, despite the fact that it might sound reasonable as a solution. All right. If there are no further questions on that, this was the most informative part. Now I'll try to be brief when it comes to the functions of these chambers. Having seen how they are composed and how they work, let's see what they practically do. And not surprisingly, the very first and generally very important function that is performed by second chambers is the participation in the constitutional amending procedure. Why that? Because, of course, especially in federal second chambers, the federal compact does not only affect the citizens, it also affects the states as such, the subnational entities as such. And therefore, their representative body, in one way or another, is involved in changing these rules of the federal compact. Now, interestingly, especially the countries that followed then the democratic form of representation of subnational interests went for a rather direct involvement of the subnational units, bypassing the second chamber. Again, here the example is given by the US Senate. If you know about the procedure for amending the US Constitution, you see that the initiative comes normally from the Congress, which means also the Senate, as a second chamber of parliament, less numerous, but still, you know, it has to reach 2/3 of the whole Congress, means of the two chambers. So the Senate is participating in the initiative phase. Of course, the initiative can also come from a number of legislatures or of constitutional conventions in each state, but it never happens. But to make it short and clear, so it is, the initiative is basically with a 2/3 majority by the Congress. But when it comes to ratification of the proposed constitutional amendment after the vote of the Congress, then it doesn't go to the Senate as such, it goes to the very states. So the Senate has no more role in that, and it must be 3/4 of the states, so which means quite a sizable number, that ratify either directly, never happens, in conventions, or through their respective parliaments. Is that okay? So the Senate participates only in the initiative, but not in the ratification process. When it comes to specific provisions, such as the fact, Article 5 of the US Constitution, no state can be deprived of its equal suffrage in the Senate without its consent, then it means that each individual state has a veto power in the Senate, right? In order to avoid that, you know, the majority of states can decide against the very existence as members of the Senate of one particular state, right? Okay, many others follow the same examples, and here you see then you can have different cases where you need either a 2/3 majority, such as in Nigeria, in Russia, or just the absolute majority of the state legislatures, like in Mexico. Or in Canada, which again has very different types of constitutional amendment procedures, and interestingly enough, the normal procedure is the one called 750. It means there needs to be the majority of provinces, 7 out of 10, and 50% representing at least 50% of the population. Again, a system which tries to bring together the territorial and the democratic element. And in some other cases affecting the very essential interest of the provinces, then you need unanimity of all the provinces. Or you can have, the voters of the respective subnational entity to be called to ratify a constitutional amendment. Typical example here is Switzerland, which needs to have a so-called double majority. The majority, so a simple majority in parliament for a constitutional amendment, and then this needs to be ratified by an absolute majority of voters at national level, irrespective of the canton they are from. But also this majority should be a majority within the majority of the cantons. Again, in order to avoid that the big cantons can decide over the will of the small ones. Same thing in Australia. It is more rare, comparatively speaking, to have a participation of second chamber only without involvement of the subnational units as such in the process of constitutional amendment. And again, this is the typical case of Germany and Austria. In Germany, it's pretty clear the procedure of constitutional amendment is one of the simplest ones. There is just one procedure for constitutional amendment, and you need to have 2/3 of the members of the parliament, the lower chamber, and 2/3 of the votes there. And I think I put it wrongly here on the slide. You need to have 2/3 of the members of the parliament and 2/3 of the votes of the Bundesrat. Again, representing a sufficient majority of the states counted based on the system that we have seen before. Right? Very simple. In Austria, the general constitutional amending procedure does not even imply the participation of the Bundesrat because it is a very, very weak federal system. Only in some particular cases when, the powers of the Länder are at stake, or the various existence of the second chamber, then the second chamber needs to participate. In South Africa, also similar. I mean, again, I can make many examples, but what is important is that you understand the rationale. Again, the constitutional changes require the support of at least 6 provinces out of 10 in the National Council of Provinces. And then also in India, you need a specific majority. So these are the examples where the constitutional amending procedure remains only at the level of the second chamber and does not involve the local parliament or local population. Well, a similar rationale applies to a different but similar way of amending constitution, which affects, changing the borders between the various subnational units. Yeah, and as a rule, without going into many details on that, there is a veto right for the individual states normally when it comes to change the borders of one subnational unit. That happens also in Italy, as you know. The procedure to move one municipality or more from one region to another region requires essentially the consent of the, well, not the Senate, which has very little to do with territorial representation, although indirectly yes, because then it requires a law but of the state, but the consent of the regional council involved. And in India, there is a rule, it's quite interesting because India is a ethnically very, very complex case. So the power to change the boundaries between the various states and even to create new states belongs exclusively to the federal parliament in order to make it more flexible. But when it comes to the most difficult one, which is the region of Jammu and Kashmir, of course, where there is, as you know, specific tension, then of course Kashmir has the veto on changing the border of that particular state. Okay, so constitutional amendment, territorial changes, very similar rationale. And then of course, in terms of numerical relevance of the function, certainly national legislation is very important. So here we have cases where the second chamber participates on an equal footing with the first chamber in adopting national legislation. Again, the model, the US Senate, all laws, with a small exception with the budget law, but in terms of initiative, not so relevant for you now. It's important to remember the Senate has the same legislative power as the chamber of the House of Representatives, and the same happens in other second chambers that are politically and constitutionally weaker than the US Senate, but are composed according to a similar rationale as we saw before, and here you have examples. Then you have cases when the second chamber does not participate equally with the lower chamber in all legislation, but only in some legislation when this is of particular interest of the subnational units. Here you have some examples. And then again you have the case which is a kind of a variation of this second category, the German case, where actually the Bundesrat does see and does vote on all laws, but in some ones they just give an opinion which can be outvoted by the parliament. Whereas in other cases, again matters that are relevant for the Länder, affecting their specific competencies, then they have a veto, an absolute veto. Either the Bundesrat votes in favor or the law cannot be adopted, as you remember, for example, the case of the immigration law we were mentioning before. Also, the second chambers in federal systems have some power when it comes to national administration. Well, obviously here only the German Bundesrat plays a role. And why? Because the German system is created following the simple logic of the fact that the governments of the Länder participate in adopting the legislation that then the Länder are supposed to implement, and therefore they participate at the very origin of the legislative procedure. So it is obvious that being a very administrative-based type of federalism, the Bundesrat has an important role also when it comes to national administration. And so the consent of the Bundesrat is required in order to adopt general administrative rules of the federation. Other senatorial systems, the second chambers, do not foresee a particular role for the senates in the national administration. Then we have an important function, which is normally the appointment of key figures. Again, only indirectly the second chambers do participate, or to a more limited extent, in appointing, for example, the head of the state. Like in Germany, it is not the Bundesrat, but it is a federal assembly composed on a equal number of representatives of the Länder and of members of the parliament. So the Länder are represented, but not through the second chamber, because this would be adopted with a democratic system of decision in order to appoint the federal president. You know how the US president is elected by a number of electors that again mix up the number of representatives of the state and the number of senators, so 2 each, which means that, you know, but okay, doesn't matter. But the fact is that there is not the Senate, but it's just the number of electors that compose the Electoral College. Then, of course, in the US, the Senate plays an important role when it comes to the impeachment procedure of the US president, and it's the Senate to make the final decisions. Finally, the appointment of judges and important federal civil servants. Again, here the second chambers do play an important role. Again, the model being the US Senate. The Constitution provides for the so-called advise and consent clause, means that every judge, for example, every ambassador, every civil servant in general, I mean, including the low level, then the low level is not so important politically, but still it follows the same procedure, requires the advice and consent of the Senate. Means advice, the Senate makes proposals, and then the final vote on the appointed candidate is also going through the Senate. Very, very important, especially when it comes to appointments to the Supreme Court, for example. Also, the appointment of a number of judges of constitutional courts goes through the second chambers. In Germany, again, half of the constitutional judges are elected by the Bundesrat, period. Very simple. In Austria, 3 out of 12. In Spain, 4 out of 12, and so on and so forth. And then there are other residual functions relevant perhaps in other disciplines, like, for example, if you study European Union law, or you always encroach upon the famous Article 23 of the German Basic Law, means that the Bundesrat needs to approve and to be involved in EU affairs and to approve every treaty change at European level. In some other case, also the state of emergency. Well, not so irrelevant when it comes to very actual happenings. As you have probably followed, last week the Spanish Senate voted the suspension of the autonomy for Catalonia, and it was again the Senate, and it was not the Parliament, the lower chamber, to decide on this emergency situation. Now, let's come briefly to the second type of bicameralism, which is less relevant in comparative terms, but still presents many, many interesting features. Here, it is not so much about the representation of territorial pluralism, but rather the representation of other forms of pluralism, notably, particularly, the political pluralism, but not only. So these type of second chambers are, as you remember from the very first slide, different types, but again they are either aristocratic chambers, providing for reflection, for giving a second thought, expertise, and in general, a slowing down institution. So whenever you hear about, bicameral systems make the legislation too slow and this is not acceptable. Well, it might be a bad idea, but this is precisely why they are there. So, I mean, that's their job in a way. We have some class-based interests, so the House of Lords, again, even after the reform in 1999, its basic structure and composition hasn't changed so much. You still have a Lord Temporal, Lord Spiritual. The former law lords were trained lawyers who had to adjudicate on a number of cases, were moved out in 2005 from the House of Lords, and they constituted, interestingly enough, they were the same people initially, who used to be the law lords and then became the judges of the UK Supreme Court. But you know, in essence, it has remained, despite the attempts for reform, a very feudal second chamber, very noble-based and class-based form of representation. Monarchic chambers means people appointed by the kings. So Belgium had an important part of that until the last reforms. In Italy, in the Albertine Statute, they were the Senate of the king. It was even called like that. Most Islamic countries, when they have a second chamber, this is of, you know, a direct appointment procedure coming from the respective king. We have still a number of corporative chambers, as I mentioned before, Slovenia, Ireland, Morocco. In Bavaria there was a second chamber like that and was abolished with a popular referendum in 1988. And then you have purely political second chambers. You know, the Italian Senate being the classical example, should be elected on a regional basis. It is, in fact, even the recently adopted electoral law adopted last week also provides, you know, similar system of election, but still the distribution of seats is regional when it comes to the Senate, because there is this constitutional constraint, and national when it comes to the Chamber of Deputies. So again, there are some differences. I think we have to close, so I will skip that. The French Senate is a very interesting case of, again, predominantly political, but still with some territorial anchoring in its composition. Is well, a very, very complex system of appointment, because this is a chamber which is indirectly elected at the levels of département, which is one of the subnational units of France, and the electoral college there is very complex, because it is composed by all the members of parliament of that particular department. Then the regional councils in that department, the members of the departmental council, and then also the representatives of the mayor of the municipalities of that particular department. So it's a quite sizable electoral college on a territorial level which has no such a big weight in France, because the departments are less relevant than the regions, and nevertheless it, you know, it expresses a very, very political form of representation, but firmly anchored on a territorial basis. Well, I guess you are familiar with the Italian Senate, so I don't need to go much into detail about that, but the fact that this chamber was designed, well, as you know, it was designed differently originally. Yeah, they don't know it. Well, they might know as a part of general culture, but the Senate originally in the Constitution was to be elected for 6 years, not for 5. And the composition is different. There are even the senators on a lifetime, plus the electorate is different, both in terms of age for voting and for being elected. So unfortunately, Professor Dani mentioned that I'm a member of Senate. This discloses my age, because it means that I need to be at least 40 in order to be able to sit in the Senate. And I'm sure that you wouldn't have guessed that. So anyway, so there were some forms of distinction, and still there are some forms of distinction, even in the way the two chambers work. But the very idea was to have a rather political form of representation. So sort of a duplication of the first chamber, true, but that was done on purpose in order to establish a broad political commitment for the functioning of the government. right? That was the rationale at the beginning, and still remains like that. Plus the fact that, you know, in a system where, especially in the origins, the regions were not developed, and a lot of the population was still, you know, illiterate. Well, the idea was that the representation had to be political in nature, and that the number of members of parliament had to be as big as possible in order to represent all the possible pluralism of the country within the two chambers of parliament. That was the idea. Then, of course, the political developments made it a little different, and you know, one may now wonder whether it makes sense to have two chambers of this same nature. Well, I will be giving a lecture on the course held by Professors Casonato and Picciocchi right now, so if you're interested in knowing more about that in Italian language, just move to the other room. No, the idea is still to have a very and exclusively political form of representation. In sum, and in order to give a few minutes then to, you know, for questions that you might still have, the political role everywhere, even in the German Bundesrat, has clearly prevailed over the territorial representation, irrespective of the different models. The democratic element has been stronger than any other, and the political within the democratic element has been stronger than any other. So one could argue, well, the Italian Senate is extremely modern in that sense, because it is, you know, a form of political representation that the others ultimately also are in terms of the way of working. When it comes to federal bicameralism, there is what some scholars have named the Madison's paradox. Madison was one of the fathers of the US Constitution. And he made clear already in one of the federal papers he wrote, saying, well, either you have a territorial representation or you have a second chamber of parliament, but the two things don't go together. And even, as we have seen, even when you have a territorial representation, well, this tends to become a political and therefore parliamentary sort of representation rather than territorial representation. So we can perhaps even paradoxically say, well, territorial representation doesn't really exist anymore in modern constitutionalism. Certainly, I mean, you need to be confronted with this dilemma. Either you want to go for a chamber of parliament, and then you give up the idea of truly representing the territory, or you want to go for a representation of territories, and then you better don't establish a second chamber of parliament, because as soon as you're a member of the parliament, as soon you are a chamber of parliament, then you start working according to parliamentary rules, which are democratic, which are political, rather than territorial. When it comes to non-federal bicameralism, there is a different paradox, the paradox of l'Abbé Sieyès, who was one of the fathers in terms of thought, political thought of the French Revolution. And again, this is the opposite paradox. If there is just one people, one nation, then you need to have just one representative institutions. So if the representation needs to be political, then why duplicate it? Why have it twice? Again, there is something, as you remember, the very first sentence in this presentation was, you have to deal with paradoxes when dealing with this subject. Right, that's exactly the point. So, if you want to have a territorial representation, so you better don't do a second chamber. But if you want to have a political representation, you don't do it either, because, I mean, then it's the same. So, well, why? What is happening today with second chambers? They are all in big troubles, and you know, everywhere there are attempts to reform them, and normally they fail. Either some small reforms are introduced, like in Belgium, you know, from 4 to 2 categories, okay. In Germany, the structure was not touched. It's just a matter of distribution of competencies, because it was impossible to change the structure of the Bundesrat. But you might know that you know, two very similar developments, at least politically speaking, was the attempt by Charles de Gaulle in as late as 1969 to try to amend the Senate, and he put all his political weight into a referendum in order to change the way of appointment of the Senate, and he failed, besides being very popular still in France, and that was the end of his political career. So it's very, very dangerous. Needless to recall, most of you who have perhaps even voted in the referendum last year, that the reform was portrayed as the reform of the Senate. Well, there were many other things in it, but anyway. And a similar thing happened in Italy. This, you know, was rejected. As a matter of fact, the senators were, of course, very happy about that. But also the very structure of the Senate, because after the referendum, the Senate has been renewed. New computers, you know, new renovations. So those who wanted to save money, welcome. But again, this was probably the end of the political career of Mr. Renzi. And the same happened in Spain, where, you know, the failure of changing the Senate and the representation of the regions was one of the causes of the constitutional crisis that Spain is experiencing right now. In Austria, there have been so many constitutional commissions built up in order to, you know, reform the Bundesrat, and it always fails. Canada, every other place. So it's a very difficult beast to domesticate, right? Even if there are these paradoxes I've been mentioning. What are the trends? Where? Obviously, and this is the last sentence, it's always like this, then if something doesn't work properly, alternative channels are explored. And everywhere, when the second chambers are not really able to represent the type of pluralism they are aimed to represent, territorial, non-territorial, political, etc., etc., different forms emerge. And normally these are bilateral forms. So there is a trend, especially in federal countries, but even, for example, in Italy it's like that. The Senate is not a territorial chamber by no means, and therefore systems of conferences emerge, or the bilateral negotiation between the special regions and the state, and so on and so forth. And similar governmental-based bilateral negotiations fora are being established everywhere in the world in order to bypass the paradoxes of bicameralism that cannot be solved by constitutional amendment. I'll stop here, but I guess we have still a few minutes.
Feel free if you have questions to ask.
Comments, questions, critics, whatever. It was so crystal clear that there are no questions.
I have a question.
You have a question.
So, Professor Palermo in his presentation emphasized that also federal bicameralism and the upper chamber in a federal system is expected to represent sub-state, or federated entities at a central level, but this role, this function has been played down by the emergence of the democratic element. We could also say by the emergence, by the catalyzing power of political parties outside the institutions. And therefore, if the Senator of Vermont, Bernie Sanders, goes to the Senate, is not really there to represent the Vermont, is not known for representing Vermont in the Senate, is known because he has a particular political agenda, because he is a member of a political party and of a faction in that political party. Now, the thing is that also political parties are on the wane. They are in a crisis. So if this element, that was the element that changed the identity of second chambers is also on the wane. What are the perspectives for second chambers? Could there be a room for rehabilitate the old functions and the old logic behind upper chambers?
More questions? I'm trying to get some time because the true, honest question is that I don't know. First, because I'm not a political scientist and I do not really know about the role of political parties. It's very difficult. What I can say, also from the experience from within, is that chambers, not only second chambers, lower chambers even more perhaps, do not work without political parties. The overall crisis of parliamentarism, which affects all type of parliamentarism, has a lot to do with the crisis of political representation and political parties. And why that? Because you can even have a parliament composed of 100,000 people, but this will never be entirely representative of the whole pluralism of society. Then you need to have some forms of some elements that filter in a way the political pluralism, and these are the parties. But even if you have 100,000 people sitting in parliament, you will have the same problem. But as 100,000 people are absolutely not feasible in parliament, even if you have 630, like in the Italian Chamber of Deputies, or 319 actually in the Italian Senate, it's far too much. I mean, it doesn't work either. Depends on, if you do not have organized political structures, then political representation becomes extremely ineffective. The parliament is not able to work if you do not have this sort of organization. Parliaments have never properly worked, actually, as parliaments. Parliaments were kind of effective just for the short time when they were supposed to be the place for making compromises between aristocracy and bourgeoisie, in a way. The typical dualism, so after the but because they were representing just one element and not the pluralism at all, just the bourgeoisie in that case, right, against the aristocratic form of legitimacy. Now, as of after the First World War, when the big parties were established, parliaments were a fiction. They were the place where the different political options were confronted and were able or not able to find a majority or to find additional compromises, right, between positions. Nowadays, especially in countries where the political system is completely collapsed, and this is one of them, this makes the parliament just the meeting of always too many people, creating a lot of chaos when there is no real guidance. So again, parliaments work only in the presence of parties, and this affects both the lower and the upper chambers because of these features that are very common in that case, because the political element prevails.
Okay, in other words, the message is that pluralism without organization is just chaos, and which means that if parliaments are to represent pluralism and not chaos, they require some form of external organization and some strong political parties. This is the assumption of well-functioning parliaments. Having said this, if you don't have other questions, other requests, okay, David?
more effective in organizing the political agenda of parliament.
I really strongly invite you to come over to the next one, but I would say rather, I think it's a very interesting point, but I would say it is rather the opposite. So it is the crisis of parties that has created this crisis of representation. Parties are not doing well in any country, right? In Italy they are doing worse, but they're not doing well anywhere, because the ways of formations, the ways according to which political ideas are formed are quite naturally becoming also others. In this communication society, people are not really ready to go out and at evening and sit for long hours on a political meeting trying to discuss about. This is happening differently. So probably parties are kind of doomed to vanish a little bit, and in the best case to become like the electoral machines they are in the United States. So they come together when there are elections. Well, in the US, don't forget, elections are all the time. And therefore the parties are not so insignificant as we sometimes think, but certainly they are differently organized than in Europe. But then, of course, when we will come to the conclusion that parties are just one of the actors of pluralism, but certainly no longer the most significant ones, well, then probably we'll have to change also the form of representation, because then the question will come, why do we need to have this whole complex machinery of parliament when you do not have the necessary ingredient to make them work? It's like having a car without gasoline to make the engine work. So difficult, but I think it's kind of natural that in some countries, like in Italy, the crisis has been accelerated by corruption scandals and so on and so forth. But an alternative has not emerged yet, so that's why we are living in a phase of turmoil.
Very good.
Very sad. Very.
Yeah, it's difficult these times to be optimist, but there are times for studying rather than time for being active, perhaps. And this is a time where perhaps it's more useful to study and understand things and perhaps to prepare the ground for some more self-conscious activity afterwards. Having said this, I would like to thank Professor Palermo for his lecture, and of course those of you who are interested in knowing more about the Italian Senate are invited, encouraged to travel to the other room, which I don't know exactly what it is. It could be one of the big rooms at the upper floor. The class will be in Italian. It's part of the course of constitutional law of the second year students of the degree. I'll see you on Tuesday next week with the other guest lecture with Professor Toniati. We'll talk about Catalonia. And thank you very much for being here, and thank you again to Professor Palermo.